Pleadings in California. Procedure. Page 8. We got like 30 more to go. Trying to carve up and read fast. California system of pleading is known as fact pleading or code pleading. This standard, distinguished from federal notice plus pleading, requires the pleading of ultimate facts to support each element of each cause of action. Pleading of evidentiary facts or bare legal conclusions is not permitted. California courts must liberally construe pleading. From CCCB 452. The pleadings permitted to be filed in the California civil action are complaints, demurs, answers, and cross complaints. Complaint. In California, all complaints and cross complaints must contain two components: a statement of facts constituting the cause of action, stated in ordinary and concise language, and a demand for judgment for the relief to which the pleader claims to be entitled. The only thing different from federal is that federal they want grounds for the jurisdiction. If damages are sought, the amount must be stated with two key exceptions. In actions for recovery of damages for personal injury or wrongful death, an amount may not be stated, and no amount of punitive damage may be stated in any complaint. Instead, the defendant may request the plaintiff to serve a statement describing the nature and amount of actual damages or punitive damages. Some complaints are subject to pre-filing requirements, such as those brought under California Government Claims Act and those seeking punitive damages against certain types of defendants. Challenges to the complaint. Various California statutes require challenges similar to those in Federal Rule 12b, with some key distinctions. Demur still exists here. Instead of or in addition to filing an answer, the defendant in an unlimited civil case may file a pleading known as a general or special demur, addressing the entire complaint or individual cause of action contained in it. Section 430 of the CCCP. In contrast, no special demurs may be filed in limited civil cases. So it's only unlimited. A plaintiff may, in contrast, a plaintiff may file a demur addressing the affirmative defenses in the defendant's answer. A party may not file a demur to an amended pleading if the grounds for the demur could have been raised in the earlier demur. General demur. The grounds for general demur are that the court lacks subject matter jurisdiction, or that the pleading fails to state facts sufficient to constitute a cause of action. Special demur include those based on a lack of legal capacity to sue, the existence of another pending action between the same parties on the same cause of action, defect or misjoinder of parties, uncertain pleading, similar to a motion for more definitive statement in federal practice, failure to plead whether the contract is oral or written, failure to file certain required certificates. I really shouldn't laugh because this is so normal to people in California or to attorneys in California. And I'm literally just like laughing. Failure to file certain required certificates. Okay. Meet and confer. At least 5 days before filing a demur. This is crazy. The parties must meet and confer and attempt to resolve the issue without court intervention. If the parties do not meet, the demurring party is granted an automatic 30-day extension to file a responsive pleading if she files a declaration why the meeting was not held and stating that she made a good faith attempt to meet. This is ludicrous. I'm kidding. This is CCCP 430.41. Wow. Okay, ruling on demur. In ruling on demur, the court considers only the material allegations pleaded in the complaint which the court assumes to be true and matters subject to judicial notice. All right, on page 10, 6 pages in. So we're at like an average of 3 minutes a page. Motion for judgment on the pleadings. A motion for judgment on the pleadings, JOP, may be made on the same two grounds as those for general demur. The court considers only the face of the challenge pleading and two matters subject to judicial notice. In contrast to general demur, the JOP motion may be brought after a defendant files an action and the time to file a demur has passed. This is section 438. Okay, so this comes after a demur. I'm thinking. Anyway, motion to quash services summons. A defendant objecting to the court's exercise of personal jurisdiction over him or to service a process must raise the objection at the earliest opportunity, most commonly by a special appearance via a motion to quash service of summons in 418. If the defendant files a motion to quash before or at the same time as filing an answer, demur, or motion to strike, he will preserve a jurisdictional objection and not be deemed to have made a general appearance. In contrast to federal procedure, a California defendant may not object to personal jurisdiction in an affirmative defense if the answer then proceed to litigate the action and raise the objection at or close to trial. English? This time in English. I mean, I reread it to myself, but before at the same time. Okay, to preserve, not be deemed to have made general appearance. Here we go. In contrast to federal procedure, a California defendant may not object to personal jurisdiction in an affirmative defense to the answer, then proceed to litigate the action and raise the objection at or close to trial. I don't think that can be done in federal procedure either. What? I don't even understand that. Motion for form non-convened, see supersection. Motion for transfer or change venue, see the supersection. Motion to strike. A party moved to strike any irrelevant, false, or improper matter included in a pleading or any part of a pleading not filed in conformity with statute, rule, or court order. Irrelevant, false, improper. Or not in conformity with statute, rule, or court order. A motion must be filed within the time allowed to respond to a pleading, which is 30 days. That feels different than federal. This is all covered in CCCP 435. The motion is based on the face of the pleading and matters subject to judicial notice. Anti-slap motion to strike. I remember hearing about this. There was a video on on this subject. Within 60 days after service of the complaint, the defendant may file a special anti-SLAPP motion to strike the complaint when the plaintiff has filed a strategic lawsuit against public participation. That's your SLAPP. Strategic lawsuit against public participation. 425. In an anti-SLAPP motion, the defendant must make a threshold showing that the cause of action in the complaint arises from activity protected by the First Amendment. Right of free speech complaint arises against free speech or petition for redress of grievances. If the defendant makes this showing, the burden shifts to the plaintiff to show a probability of prevailing on the benefits. A defendant prevailing on an anti-SLAPP motion is entitled to costs and attorney's fees. Restricted use of anti-SLAPP motion. Because the California legislature began to perceive a disturbing abuse of the anti-SLAPP statute, it precluded defendants from bringing anti-SLAPP motions in actions brought solely in the public's interest or on behalf of the general public. And so, and in actions brought against sellers of goods or services arising from the defendant's statements relating to his or her competitor's business. SLAPP bag suits. A defendant who previously prevailed on an anti-SLAPP motion may bring a SLAPP bag suit against the former plaintiff. SLAPP bag is a cause of action for malicious prosecution that arises from previous lawsuits dismissed pursuant to an anti-SLAPP motion. Insert. General and specific denials permitted. Except in certain limited circumstances, the defendant may file a general denial which denies each and every material allegation of plaintiff's complaint. Defendant also has the option of filing specific denials which deny particular paragraphs or parts of the complaint and which permit defendant to deny allegations on the basis of information and belief or lack thereof, with some exceptions. If the plaintiff has filed a verified complaint, the defendant must respond with a verified answer that contains specific denials. Any material allegation is not denied by defendant's answer are deemed admitted, and in pleading affirmative defenses, defendant must adhere to the same pleading standard as that required of plaintiffs in pleading causes of action in the complaint, or the answer may be subject to a general demur. Time. Defendant has 30 days from the date service of process is deemed complete to file an answer. If defendant instead brings one of the demurs discussed above and the court overrules the demur, the defendant must file an answer within 10 days from the date of service of the court's ruling, unless the court orders otherwise. Although there is no fixed time period for filing an answer after denial of motion to strike, courts generally follow the same period as for a demur. Effective failure to answer, default, and default judgments. A default is simply a notation in the case file by the clerk that there has been no answer other than or other general appearance filed within the time permitted by the rule or statute. A default judgment is entered when the defendant did not appear and defend the case. Entry of default. So that sounds the same. Actually, entry of default sounds the same. Default doesn't sound the same. Default judgment sounds the same. Entry of default sounds the same, but just plain old default? I'm not sure we have that. Federal entry of default. If a plaintiff against whom a judgment for relief is sought has failed to plea or otherwise defend and that fact is made to appear by affidavit or otherwise, the clerk must enter the default of that party. Entry of the default may also be ordered as a result of defendant's misconduct, such as for failure to comply with discovery obligations. Once a default has been entered, the defaulting party may not proceed with the action unless the default has been set aside by the court. The defendant against whom the default is entered loses the right to contest liability. In California state court practice, the party requesting entry of default must mail a copy of the request to the defaulting party. Okay, so really slight differences here that I'm noting. Misconduct, failure to comply with discovery. Not sure that exists at federal court. Default judgment entered by the clerk. If 1, the action arises upon a contract or judgment for the recovery of money or damages only. 2, the action is for a certain or ascertainable sum. And 3, defendant was not served by publication. The clerk may enter a default judgment. This is pursuant to 585. Default judgment entered by court. When the plaintiff requests the court to enter a default judgment in cases where the clerk may not do so, as above, the court conducts a prove-up hearing, either in person or the plaintiff's submission of affidavits and other evidence. The plaintiff must make a prima facie case for the amount of her damages or other relief. The plaintiff need not prove liability unless the complaint fails to state a cause of action and the factual allegations do not support the judgment requested. The court then enters judgment for the amount pleaded in the complaint, or in a personal injury or wrongful death case, the amount stated in the statement of damages or statement of punitive damages. The defaulted defendant is not entitled to notice of the hearing and has no right to appear or submit evidence on damages. Wow. Setting aside a default or default judgment. In California State Court, CCP sections 473B and .5 permit a defaulted party to move the court to set aside an entry of default and default judgment. Cross complaint. A defendant must seek affirmative relief against the plaintiff in a separate cross complaint, not in the answer. Note, California uses a single label cross complaint to include the federal counterclaim, cross claim, and third-party complaint, with limited exceptions if the defendant has a related cause of action against the plaintiff, one that arises out of the same transaction or occurrence. The defendant must bring that cause of action against the plaintiff as a compulsory cross complaint in the original action, or the plaintiff will be barred from bringing it in a separate lawsuit. Any other related cause of action defendant has against plaintiff may be asserted in a permissive cross complaint or in a separate action. So cross complaint, single label, includes federal counterclaim, cross claim, third party complaint. Lovely. One that arises out of the same transaction and occurrence is compulsory. and can be barred. Any other cause of action is permissive, i.e. not relating to the transaction occurrence. Alternative pleadings. A party generally may set out as many alternative claims or defenses as he may have, regardless of consistency. One exception is that verified complaint being sworn may not plead inconsistent facts. Facts may be pleaded based on the plaintiff's personal injury or information and belief, or they may be incorporated by reference. So one may be verified, sworn. Others can be whatever that means. Pleading facts. The general rule of pleading is for ordinary and concise statements of ultimate facts, but there are rules for special circumstances. In California, fraud is the most common cause of action, subject to a heightened specificity requirement for pleading, but the requirement also applies to additional causes of action, including civil conspiracy, tortious breach of conduct, unfair business practices, and products liability claims among multiple defendants arising out of exposure to toxins. Amended pleadings. Amendments. All right, so fraud is the most common heightened specificity requirement for pleading. And then there's all this other stuff. Amendments. In California, a party may amend once as a matter of right. That's the same as federal. Before an answer or demur to the complaint is filed, or after, but before the hearing. So that's what's different. On the issue raised by the demur, if the amended pleading is served no later than the date of the filing, for filing in opposition to the demur. Otherwise, a stipulation of the parties is required. Section 472. Thereafter, a pleading may be amended only by leave of the court upon motion. CP 473. Leave of the court is liberally granted. That's different terminology for the same thing in federal court. Common amendments are those to add or correct pleadings or causes of action, to conform to pleading to proof, or to correct a stricken pleading. Amendments to pleadings in response to demur are limited to 3 amendments absent a showing that additional facts can be pleaded such that the defect can be cured. 1. Amendment to add a new cause of action against a defendant already named. California Doe amendments. All right. That's the 3rd. Certification upon presenting paper to court. I'm sorry, that's not right. That's the next section. The 3rd is to conform to evidence. So let's read these in deeper detail. The 3 amendments, absent a showing of additional facts, starting with amendment to add a new cause of action against a defendant already named. An amended complaint that adds a new cause of action may relate back to the date that the original pleading was timely filed, accordingly to the relevant statute of limitations, thus making the amended pleading timely as well. Relation back requires that a new cause of action be based on the same general set of facts as those of the original complaint. The amended pleading involved the same accident and injuries. And 3rd, amended pleading referred to the same offending instrumentality. California Doe amendments. California, this is the 2nd type of amendment. It doesn't require what? New facts? Additional facts. California permits a defendant to be sued under a fictitious DOE designation if the plaintiff generally ignorant to the identity of the defendant at the time she files her complaint. The plaintiff may then amend the complaint to substitute the true name of the defendant in place of the DOE designation. This is under 474. The DOE amendment procedure has several requirements, 1, 2, and 3. 1, the original complaint must be timely filed and must contain charging allegations against all defendants, including those designated DOEs, as DOEs. The plaintiff must be genuinely ignorant of the identity of a fictitiously named defendant, of facts giving rise to a cause of action against that defendant, or of the facts that the law provides a cause of action. And third, plaintiff's ignorance must be pleaded in the complaint. If these requirements are satisfied, the plaintiff generally has 3 years from the filing of an original complaint to discover the identity of the DOE defendants and serve them with amended complaint. Under fast track, DOE defendants may not be dismissed until after the presentation of evidence at trial is completed. Under the principle of relation back, the amended complaint against a defendant who has been properly substituted for a DOE designation will relate back to the filing date of the original complaint. New causes of action against the newly substituted defendant will also relate back to the original complaint if they involve the same general set of facts, same accident, injuries, and same instrumentality. So I can file a complaint for whoever stole my car battery and tennis bag right now, saying I don't know who they are, and eventually in 3 years, put some idiot's name in there to conform to evidence. In California, the court may order an amendment to conform to proof if material in California between the pleading and proof at trial and the variance has misled a party to his prejudice. Section 469. I must have missed a word there. I don't understand it. In California, a court may order an amendment to conform to proof if a material variance exists between a pleading and proof at trial. And the variance has misled a party to his prejudice. So in my pleading, I don't even want to hypothesize. Let's just keep going. Certification. I'm on page 14. Only 14. I mean, 6 pages, 28 minutes. I think that's like, I can't even add. That's still 3 minutes a page? Yeah, right. 3 times 6 is what? 3 times, is that even 3 times 6? That's 18. It's more like 5. It's like practically 5. Certification upon presenting paper to court. California Sanctioned Statute, CCP, Section 128 is nearly identical to Federal Rule 11. The attorney or unrepresented party, by presenting to the court a pleading, written motion, or other paper, certifies to the best of their knowledge, information, and belief formed after an inquiry reasonable under the circumstances. I just don't understand why it's broken down into 4 subparts now. Paper is not presented for any improper purpose, harassment, delay. 2, the legal contentions therein are warranted by existing law or a non-frivolous argument for the modification of existing law. The allegations of factual contentions either have or upon further inspection or discovery are likely to have evidentiary support, and denials of factual contentions are warranted on the evidence or, where specified, are reasonably believed to lack information and belief. So at least 1 through 3 I can say are the same as Rule 11, right? I don't know about this last one. And sanctions. A court has discretion to impose sanctions limited to what is sufficient to deter repetition of such conduct against the party who presents a paper to the court in violation of the above requirements, either on the court's own initiative or on a motion of the opposing party. If appropriate, sanctions may be imposed against parties, attorneys, or law firms and may consist of non-monetary directives or monetary penalties, including payment of expenses and attorney's fees incurred because of the improper paper. Unlike federal court practice, the court will also assess whether the party seeking sanctions exercise due diligence. Court's initiative. A court, on its own initiative, may enter an order describing the matter that appears to have violated the statute and to direct the proponent to show cause why sanctions should not be imposed. A party has 21 days to correct or withdraw the matter. Party motion. A party believes that his opponent has presented a paper in violation of the statute may serve a motion for sanctions on the party. The party does not withdraw or correct the matter within 21 days. The moving party may then file a motion for sanctions with the court. That sounds similar too. Joinder of parties, compulsory joinder. In certain circumstances, certain situations, a plaintiff must join all interested persons or entities or face dismissal of the lawsuit. Section 389. Analysis of a compulsory joinder issue follows a 3-step process. Should the absentee be joined? Can the absentee be joined? If not, should the action proceed in his absence indispensable? This is the same as federal, just saying. Maybe the breakdown of each of those components is a little different. So should the absentee be joined? An absentee should be joined when complete relief cannot be accorded among the other parties to the lawsuit without the absentee's presence, or the absentee has such an interest in the subject matter of the lawsuit that a decision in his absence will, as a practical matter, impair or impede his ability to protect that interest, or leave any other party subject to a substantial risk of incurring multiple or inconsistent obligations. Sounds similar. Can an absentee be joined? Assuming that a party should be joined under the analysis above, the next question is whether he can be joined. Whether the court can obtain personal jurisdiction over the defendant, and whether the court will still have a subject matter jurisdiction over the action after joinder of the defendant. If the court has personal jurisdiction over the defendant to be joined and her joinder will not destroy subject matter jurisdiction, she must be joined. Hello? That didn't sound right. Should the action proceed without an absentee? Kryptonite up here. If absentee cannot be joined, for example, the plaintiff cannot serve process on the absentee, the court must determine whether in equity and good conscience the action should proceed among the parties before it or should be dismissed, the absent person thus being regarded as indispensable. The decision requires consideration of the extent of prejudice to the absentee or available parties of a judgment, the extent to which prejudice can be reduced or avoided by means of protective provisions in the judgment, the shaping of relief or other measures, the adequacy of the judgment rendered without the absentee party, and whether the plaintiff will have an adequate remedy in another forum if the case is dismissed for non-joinder. I feel like this is all pretty reflexive. I don't know if there's something somewhat different. I didn't notice that. And that's from the federal rules of compulsory joinder and determining if a party is indispensable. Permissive joinder, I wish they would tell me what's different. In California state courts, plaintiff may join together if they are asserting a right to relief arising out of the same transaction occurrence or series of transactions or occurrence when a common question of law or fact arise, and they have a claim adverse to the defendant, and similar requirements apply to permissive joinder defendants, and this is 378, 379. I'm looking at page 16. I'm on minute 35. I feel like I'm at least going to get to discovery because I know I'm about halfway through. Just about one page short of halfway through. Joinder of claims. Joinder of claims in California state courts is very similar to joinder in federal court. A plaintiff who asserts a cause of action against a defendant may join any other cause of action he has against the defendant, regardless whether they arise to the same transaction occurrences or involve the common question of law or fact. 427. This broad rule is limited only where there are several defendants in the action. In that case, there must be at least one question of law or fact in common to all. The court retains the jurisdiction in order to discretion to order separate trials of some of the claims if unfair prejudice or undue delay of the trial would result. All right, so seems similar. Class actions in California state courts. California, class action may be maintained when the question is one of common or general interest of many persons, or when parties are numerous, and it is impracticable to bring them all before the court. Section 382 on ruling on class action issues. California courts often rely on the language of Federal Rule 23 and the federal cases interpreting it. The minimum requirements for certification of a class action are thus an ascertainable class and a well-defined community interest among class members. All right, so they rely on Rule 23, but that's the prerequisites. There's only two. Unless there's more. Next, it says the community of interest requirement involves, they just don't call it a community of interest. Analysis of federal factors to this community of interest requirement, including whether common questions of law in fact predominate. The class action device will result in substantial benefits to the party and the court, and the class representative will adequately represent the class interests. Okay. Opting out, any class member who does not opt out of the class action after receiving proper notice of the opt-out right will be bound by the judgment of the action. Notice. California notice procedures require in some respects from the federal requirements in some respects. First, in some cases, California courts permit notice by publication in lieu of individualized notice. That's a California rule of court. Second, in California, the court may impose the cost of notice on either plaintiffs or defendants. Federal procedure requires the cost of notice to be borne by the plaintiffs. Aggregation of claims. Claims of individual class members are aggregated to satisfy the amount of controversy requirement for California subject matter jurisdiction. settlement, and dismissal of claims. The requirement of court approval and notice to class members are similar to those under Rule 23C. Representative suits. In representative suits, a person or entity sues on behalf of the real properties and interests. Representative suits are not always subject to the same strict requirements as those governing class actions. For example, the representative is not necessarily required to have an injury in fact that is typical to the group he represents. Common types of representative suits are those brought by taxpayers, shareholders, homeowners associations, labor unions, and consumers injured by unfair business practices. I feel like that's different. Interpleader permits a person in the position of a stakeholder to require two or more claimants to litigate among themselves to determine which, if any, has the valid claim where separate actions might result in double liability on a single obligation. This is the same so far. The plaintiff stakeholder does not have to admit liability to any claimant, and the claim does not have common origin, does not have to have common origin. Once the court has allowed interpleader, the trial by jury is available to determine the notice of fact. Issues of fact. California law is unclear on whether the stakeholder needs to be completely disinterested party. That's unclear. Okay. That makes me wonder if it's unclear in the federal law. I thought that was clear. They didn't. I wouldn't even think of them as disinterested. Why would they even ask for an interpleader if they were disinterested? Which is crazy. Intervention may be granted to a party by right or permissively. Intervention in California state courts is similar to that of federal court. That's great. Thanks for telling me that. These are like opinion statements as to how different they are in federal courts, like opinionative value statements. But they're not telling me how they're different. So if you don't want to like just highlight that in a different color or something, like what the difference is, that'd be great. Right here, I'm just kind of like, okay, this is similar. And then over here, it's similar. Similar. Intervention of right is available whenever the app. Thankfully, I have this note card here, so I can compare it. When an applicant claims an interest in the property or transaction that is the subject matter of the action, and the disposition of the action without her may impair her ability to protect that interest, that is exactly the same. But it says in parentheses here, unless her interest is already represented, and this is CP 387. Permissive intervention is available when the applicant's claim or defense and the main action have a question of fact or law in common. In California, so here's the difference. The principal issue that arises in permissive intervention is whether the potential intervener's interest is direct and immediate, which is required for permissive intervention, or is indirect and consequential, which would defeat intervention. In federal intervention, no personal pecuniary interest is required. Caveat: in all cases of intervention, the application must be timely, a matter within the court's discretion. So it doesn't tell you what timely is, it just says per the court's discretion. Third-party practice. Impleader. A defending party may implead a non-party. In California, the complaint that the defending party files is called a cross-complaint, and the parties to that complaint being called third-party plaintiff, who is the original defending party, and the third-party declarant, who is the party being added. Body is breaking down from taking acetaminophen. Oh my God. Ow. Claims for indemnity. A defending party may implead a non-party who is, or may be liable to her for any part of a judgment that the plaintiff may recover against her. For example, claims based on indemnity. Venue need not be proper for the third-party defendant. All right. So these are called cross complaints because everything is called a cross complaint. Non-indemnity claims. As part of the cross complaint, the third-party plaintiff, i.e. the original defending party, may join other non-indemnity claims she may have against the third-party defendant. The cause of action in a permissive cross complaint, adding a new party for any purpose, not only indemnity, must either arise out of the same transaction or occurrence as the original plaintiff's cause of action against a third-party plaintiff, or it must assert a claim or interest in the subject of the plaintiff's action against the third-party plaintiff. The third-party plaintiff may then join any new third-party defendant if it would not violate California's liberal joinder statutes, and may join any other cause of action he or she has against any of the third-party defendants. This is Section 428 of the CCCP. Severance of third-party claims. In any event, even if jurisdiction exists, the court may sever any third-party claim to be tried separately if it is just to do so. Example, if addition of those claims would lead to unfair prejudice to one of the parties, or if the case would become unduly complicated. Response of third party. After he is joined by the cross-complaint, the third-party defendant files an answer to the cross-complaint, and he may assert defenses to the plaintiff's original claim as well as defenses to a third-party liability asserted against him. In addition to filing an answer on the cross-complaint, a third-party defendant may file a special answer asserting any affirmative defenses against the original plaintiff that the third party has. That's Section 425. Cross-complaint against a co-defendant. In California, co-parties may assert claims against each other that arise out of the same transaction or occurrences as the main action by filing cross-complaints again. A cross-complaint against a co-defendant is permissive, requiring a transactional relationship to the original complaint or a claim or interest in the subject of the original complaint. This is from Section 428. We've now entered into discovery, and I may read it alone, highlight what's different if I notice it, and then get back into pretrial conferences. I don't even know if that's worth talking about. Dispositive pretrial motions and procedures, that may be worth looking at, maybe in comparison to the chart. In the federal outline, trial, jury trial specifically, wow, a lot on juries, and attack of judgments and orders at the trial court level. There's a motion for judgment notwithstanding the verdict, motion for new trial, remiture, adjudicature, judgment and appellate review, judgment on future cases, claim preclusion, issue preclusion. All right, so let me get into that sometime.